Good morning, everyone, and welcome to this morning's construction cast. Thank you for joining us. We're taking a look this morning at international arbitration. This is the second in our series in the lead up to Riyadh's International Disputes Week, which is taking place next week in Riyadh. If you are joining us in Riyadh, please do check out the Lionshead Masterclass, lionshead.com/masterclass. We've got a whole day conference taking place as part of the week, and our speakers this morning are all taking place in various talks. I know Khushboo's got lots of talks going on. Fatima is speaking at loads of things, and Sam is also out there speaking at a number of events. So the website for that, I'm sure you know it if you are planning on heading out to Riyadh, is ridw.org. So this morning, talking about international arbitration, it's such a broad topic, but we've got some fantastic speakers. I'm just going to quickly introduce them. We've got Fatima Balfaqeeh, who, if you are a long time construction cast viewer, you've probably seen her on sessions before. She's a UAE qualified lawyer, independent arbitrator, mediator, and business consultant. Her career began 2 decades ago in government and semi-government entities in Abu Dhabi, where she led on contracts and procurements. She's worked within commercial, legal, and operational matters across the construction, government's enforcement of contracts, and procurement. In 2018, Fatima launched her own consultancy, which later evolved into a law firm. That's Fatima. Khushboo Shahdadpuri is from Tamimi and Company. She's ranked as a future leader in arbitration by Who's Legal and a rising star by the Legal 500. She's dual qualified, admitted to practice in Singapore and the state of New York, although she's currently based in the Middle East, where she heads up the construction practice. Her focus is on international dispute resolution. She's worked on gas pipelines, solar power plants, World Cup stadiums, and other kind of prominent big projects. And finally, coming to us from the UK, we've got Karim KC from Gatehouse Chambers. He's a dynamic silk who has been consistently regarded as a leading practitioner by the legal directories. One of his specialist areas is international arbitration, in which he acts as counsel and sits on panels as a sole or panel arbitrator, both here in the UK and the Middle East. Sam has very kindly joined us, even though he's got a hearing this morning, so we're going to have to make sure we keep to time. So we're going to jump straight into the first question, and we're going to come to you, Khushboo, and ask about a very broad question. Is arbitration actually global? We know it exists as a concept around the world, but is it truly accepted worldwide?
Thank you so much, Annie, and good morning to everyone joining us for today's session. I think you raised a really interesting question, Annie. I think the easy answer to that question is really how long is a piece of string? That's the short answer to your question. But the longer answer is that while arbitration is obviously a global phenomenon in the sense that it's well used by international parties, and there's just no two ways about that, especially for resolving cross-border disputes. But how it is accepted globally actually differs depending on which region we're looking at. And I think every region will probably have a different answer to that question. For instance, the whole proliferation of arbitral institutions, which I think has been happening across the globe. Now, that can be viewed sometimes as very economic in nature because every jurisdiction would want to create its own leading arbitral institution, because ultimately it's an investment that's coming into that jurisdiction if more disputing parties sign up to that region's arbitral institutions. But this in itself also highlights the whole international nature of competition between the different arbitral institutions worldwide, because every arbitration service provider wants to obviously be a leading service provider for disputing parties. So this in itself shows that it is actually still very much global. But again, every country has also passed such different arbitration-related laws and legislations. To a huge extent, these laws do provide for similar provisions for challengers, for enforcement, and they are obviously based, a lot of them, on the model law provisions. But there are, again, certain nuances because certain jurisdictions still don't have an arbitration legislation. Although they are in the minority, they still exist, some of them also in the Middle East. And again, this in turn affects how disputing parties in those jurisdictions then view arbitration, because they would be less inclined then to sign up to arbitration if that jurisdiction doesn't have a proper arbitration law as opposed to those which has. So to answer to your question, really, arbitration is global indeed, but it again depends on who you're asking and which part of the world they are sitting in.
Thanks, Khushboo. In fact, we're looking at the Middle East more specifically. Khushboo mentioned there the number of arbitral institutions, and the Middle East is no stranger to having lots of different institutions now. Does this give more choice, or is it causing confusions and complications?
Hi, everyone. Good morning and good afternoon, depending on where you are in the world. First, I will start with thanking Limesleet for conducting such important construction casts to shed the light on important topics in arbitration and ADR in general. If we take a deeper look into the region, it depends where are you looking in the region. We have seen in the UAE an effort to consolidate the arbitral institutions with what happened with the Decree 34 on 2020. I think, or 2021. Time is a blur at this time, at this point, where a consolidation of three arbitral institutions was merged into one in order to combat the phenomena that is happening in the Arab states, which is the overpopulation of arbitral institutions. It definitely causes more confusion than not. However, that being said, we have seen a steady increase of internationally recognized arbitral institutes, notwithstanding the smaller kind of completely local and I would say not very busy arbitration centers. So we see them coming in, doing their rules in a way that is at par with international standards, trying to attract and give confidence to the international market to attract the work. Is it a positive or a negative? It is being tested right now, in my views, and I would say that very conservatively. I think the region has some nuances that needs to be addressed by more regional arbitral institutions. There is a time and a place to use international arbitration institutions, and there is a time and a place to use the regional at an international level arbitration institution. So in short, yes, it is very evident that there is a boom of a number of institutions, but I think at the same time there is very formidable efforts of consolidation and aligning with international standards.
Thanks, Fatima. Sam, what about your experience of arbitration in the UK versus the Middle East? Are there major differences, and what do we need to be aware of?
Yeah, it's not a bad question. Thanks, Annie, and to Limescale for this event, and delighted to be speaking with my esteemed colleagues, and hello to everybody. So, I mean, as both of my panelists, the panelists have said, I think, in theory, there should be little difference in arbitration around the globe, because one of the purposes of arbitration and arbitration law based on the UNCITRAL model law is that there's harmonization of principles and procedures. So that's one of the key points about arbitration and international arbitration. In terms of arbitral institutions across the UK and the UAE, there tends not to be a huge substantial divergence in the procedure, but there are some, as Fatima said, some nuances that people who practice in the UAE need to be aware of. And I'll just give you two examples, for instance. So the time limits for challenging an arbitrator who's been appointed by a tribunal. DIAC, which is the Dubai International Center rules, provide, I think it's Article 15, you've got 15 days from the receipt of the notification to challenge, or when you should have known when the challenge arises, for instance. The ALCIA, which is a London commercial arbitration center, Article 10 provides 14 days from the formation of the tribunal and 14 days when the party became aware. And just to put a third person in the mix, the ICC give 30 days for being notified, or 30 days from when you became first aware of the situation. So that's one example. So I mean, there's consistency in terms of the process, but the time limits are very different. Expedited procedures is probably another really good example, because DIAC provides under their rules for a process if the value is over 1 million dirham. It's agreed in writing, and exceptional urgency is determined by the DIAC arbitration court. The LCIA, for instance, however, there's no express route or procedure, but Article 14.5 provides a really general kind of power to expedite the process if it's really urgent. And again, the ICC provide a similar kind of process. But in terms of the actual differences in the jurisdictions, putting aside the arbitral institutions, I think probably the main thing between the two, UAE and the UK, is the appointment of arbitrators, because Fatima mentioned with the consolidated UAE law and arbitration, that now under the new amendments, I think it's Article 10 allows for the appointment of arbitrators. And in the first iteration of the new law, there was some ambiguity as to who could be appointed as an arbitrator if you were a member of a trustee or the executive management of an arbitration institution administrating in the UAE. But now that provides an exemption. So you can be an individual appointed as an arbitrator who serves on a board of an arbitration institution subject to 8 conditions. And I'm not going to go into those 8 conditions now because it will be here for a while, but it's extremely nuanced and it's something to be aware of in the UAE jurisdiction. So I think those are the main differences between the two, but in theory, there should be little.
Yeah. So I guess it's a matter of making sure you know those details so you don't get caught out, assuming that it's similar to what you do in the UK or in the Middle East, wherever you're usually based. Sam, what about other forms of dispute resolution? Because here in the UK, adjudication is extremely popular. Is there a place for adjudication in the GCC?
Yeah, I mean, absolutely. And it's already well established, as I'm sure most people will say. I mean, there's no doubt that arbitration remains in the GCC's region the most effective and preferred dispute resolution process for resolving, say, construction disputes. There's no doubt about that. But there is a place, and I've always thought this, for a framework of international principles and standards which allow for greater clarity and visibility. And to that extent, the FIDIC form of contracts, which is used by most, kind of contractors throughout the region, I found, involving most construction work. So that allows plainly for adjudication, rapid process of determination, usually between 28 days and 42 days. And it's not new, because FIDIC forms, certainly in my experience and speaking to other colleagues who've been doing this for a bit longer than me, they've said that in the GCC, FIDIC contracts have been around since the 1970s. And so it's been around. The texts are pretty much always English common law. And the interesting interface is going to be in the future, I think, and happening now, is going to be with the codification of civil law and how that fits in with the FIDIC contracts. And there's going to be a really interesting debate and interface with, for instance, the Saudi civil transaction law and how that fits into FIDIC contracts. And there's going to be examples of areas that we're going to probably need to discuss in another construction cast in due course. But yeah, I mean, adjudication is there. It has been there. A common misapprehension is that, it's not private. It is if it's consensual. But the only kind of key characteristic with adjudication is that it only deals with monetary remedy claims. So you can't get enforcement actions or interim relief and all that kind of stuff. It's just about money.
Okay. Thank you. Fatima, we're seeing a lot more DABs being included in construction contracts in the region. How do these work?
So I'll piggyback from Sam's answer and we'll go on. He have laid the ground very nicely in terms of giving the history of where adjudication started in the region, and it did indeed start with the use of the model contract, which is the FIDIC model contract in construction. In those contracts, it have mentioned adjudication, and it have also mentioned dispute adjudication boards. Now, the difference between dispute adjudication boards and adjudication when it's used in the UK or in comparison to the region is that the UK have given a legal enforcement strength to adjudication through the courts, versus here in the region, it is absolutely a commitment that is based from the contract or the contractual agreement. So it lacks, so to speak, some teeth when it comes to enforcing the decision of the dispute adjudication board. back in the day when I used to work for master developers, I was actually guilty of being one of the people who used to cross out adjudication or DABs out of the FIDIC contract, because we had a very clear preference to resolving disputes either through courts or through arbitration, which seemed to be safer in terms of enforcement. But now we see a big push towards repopularization of dispute adjudication boards. There is a preference in the market for on-demand dispute adjudication boards rather than standing dispute adjudication boards. Have seen, as I said, an increased popularity, both especially in capital construction government contracts, whether it's infrastructure works or mega projects in Saudi, KSA, or in the UAE as well. There needs to be, from my perspective, a lot of more training when it comes to what are dispute adjudication boards, how do we deal with them, what is the difference between standing and per request or at the time of the dispute happening, what is the value of it, even if it's a commitment out of the contract, and how can we utilize it as parties, or it will end up being another situation where we see with mediation, where it's just a tick in the box that we went through DABs and try to bypass it in order to go for the more enforceable form of ADR, whether it's arbitration or if we're going for litigation. So we still have way to go in terms of raising awareness about this, but absolutely we're going in the right direction, and I'm very optimistic when it comes to repopularization of DABs.
Thank you. Khushboo, what about your experience in DABs and as well as statutory adjudication? Because you've done lots of work in Singapore as well as the Middle East. How are they used there?
Sure. I think one of the biggest advantage of DABs, along with any form of statutory adjudication, is that it really provides a quick resolution of the parties' very often technical dispute. And its intended purpose is to resolve these disputes so quickly in a cost-effective manner, such that I think the other side of the coin is that there's always this argument as to whether the adjudicators can really properly decide on such disputes in such streamlined timelines, especially when, we're talking about really technical disputes in the construction sphere. One of the main issues that does prevent DABs from being very commonly used, and I think this is not just a problem in Singapore, but also in the Middle East, as Fatima has alluded to, is that because they are a creature of contract, we don't really see them being making its way to the final contract very often. So it's obviously in the recent forms of FIDIC, they are there. There's a provision for DABs, but very often parties will, in the process of negotiating and fine-tuning their agreement, would then either remove them completely or limit their scope to very certain disputes or to very certain periods, after which they can't be used. There's also issues of how binding a decision of these engineers or adjudicators are for DABs. Now, with statutory adjudication, it's a bit different because it's mandated by legislation. So Singapore has its own statutory adjudication provision called the Security of Payments Act. I think Australia has it, so does the UK. And obviously, because it's already mandated, it's part of the legislation and laws, it's widely used in the countries that have these such legislations. Usually, claims for payment under a statutory adjudication will go on simultaneously, even if the formal dispute resolution procedure has commenced. So they sort of simultaneous parts to get the same decision from either the adjudicators or the tribunal, depending on which one's faster. And then obviously, because the tribunal will take a longer time to make its decision, the statutory adjudicators will then be used, its decision will then be used to sort of counter, offset any of the claims being made in the arbitration. The other issue with DABs and both statutory adjudication is that whether the decision can be made in such a quick period of time on a prolongation course where there's just so much costs and documents and substantiation that needs to be reviewed properly. And I think this is one of the issues that we saw in Singapore, which actually led then to Singapore's adjudication regime being streamlined to limit the claims that are then being brought under the Security of Payment Acts and those that then go on to litigation or arbitration. It's just because there was just no time for the adjudicators or the decision makers to sort of review and make sure each and every single cost that's being claimed has actually been incurred. So these are really some of the big concerns we see in Singapore on DABs, on statutory adjudications. And I think the same concerns is also sort of commonplace in the Middle East.
Yeah, absolutely. Okay, thank you. We've got some questions coming in from the audience. Perhaps, Sam, you might like to take this one on mediation. It says, in light of the recent decision in Churchill in relation to the courts having the power to compel parties to seek ADR, how do we think this might be accommodated in civil law countries?
Well, I mean, I think there's a bit of a misapprehension that mediation is not already established in civil law jurisdictions, and in particular in the GCC area. It is. And in fact, culturally and religiously, it's embedded in our culture and religion. So mediation is well established. I think the Singapore Convention on Mediation is significant. It's going to make a big difference. And in terms of how this can be accommodated in civil law countries, well, number one, the answer to that technically it's already there. And number two, like any common law jurisdiction, the key is to emphasize the importance of mediation as a dispute resolution mechanism for the right case. And I think that's the most important thing. There's no point going into mediations. For instance, I was involved in one recently when the two parties just didn't want to mediate. And all it did actually was to create more animosity between the two parties as opposed to lead to any resolution. So it has to be the right case, in my view.
Thanks, Sam. And another question that's come in, maybe Fatima, you've got a view on this one. In relation to the adjudicator's decision being binding but not legal, how does this lie within civil law jurisdiction?
So it is binding as much as any contractual agreement is binding. So it's not we're saying that it's not enforceable by legislation, so it's not statutorily enforceable, but it's absolutely legal. If we're gonna see the question correctly, so it becomes like enforcing any other contractual agreement that you have come with, and it's the same arrangement with mediation. So at the end of mediation, you have your mediation agreement that is the result of a successful mediation, and again, it is enforceable, similar to any contractual agreement that have happened. If I can also just go back to the answer that Sam have rightfully mentioned, I think whether we're speaking about adjudication, DABs, mediation, the pitfall that we fall into as lawyers advising our clients is pitting each type of dispute resolution against each other. So saying it's mediation or arbitration, it's DABs or mediation, and they're truly all tools to help you resolve resolve the dispute. So if we choose the right tool for the right dispute, then we will be able to yield a better result. We've seen fantastic examples happening out of the UAE and out of the region, where expert determination actually was a fantastic tool of resolving disputes, because both parties willingly, similar to mediation, similar to DABs, willingly come together, take this matter into a technical expert to ask him. And I think this is where the nuances of the region needs to be understood a little bit, to ask him what is deemed to be fair, a fair deal. And if we have mediation being tailored a little bit in order for it to be less facilitative and more evaluative mediation in the region, it will work better. Because yes, mediation has different types within it, but I really believe evaluative mediation is sought out here more than facilitative, because the parties want somebody else to tell them what is deemed to be a fair agreement between them. And this is the model of the Majlis. This is the model of where we see it in our culture, in our religion, where the elder of or somebody very well respected, who seems to be neutral, that will come to tell the parties, okay, this is the situation. I see that this is the fair outcome for both of you.
Thanks, Fatima. Our final question this morning that we have planned is about green arbitration. Now, on construction costs, we quite often talk about sustainability and climate change and all of those things, but normally we're talking about in the actual construction process itself. So what do we mean by green arbitrations, Khushboo, and what is the arbitration community doing to reduce their carbon footprint?
Thanks, Annie. I think there's a lot of talk about green arbitration, as it's a buzzword for the last few years. It's all we all know. In the region, the community is doing indeed a fair bit, but maybe going one step back as to what green arbitration is. And there's a lot of confusion as to whether this means arbitrations pertaining to greener projects. But green arbitration actually means how we resolve disputes and resolving it in a way that's environmentally friendly and just limiting or reducing our carbon footprint. We have this sort of organization called the Campaign of Greener Arbitrations, and it's a worldwide organization. And they have adopted a great set of model rules or procedural rules to promote greener arbitrations and greener practices in arbitrations, aligning with the objectives to really reduce carbon footprint in the process of resolving disputes. So really going hand in hand, such that not either one of these considerations are sacrificed in the process of resolving disputes and being green. I think one thing that's actually notable is the recent UAE arbitration amendments that have just been introduced a few months ago. And those actually have gone a step further by imposing a requirement on the arbitral institution, so that's defined as the competent arbitration institution, to actually provide the technology that's necessary to carry out the arbitration proceedings in accordance with the required standards and in a green manner. And I think that's fascinating to see a legislation actually mandating this requirement on an arbitral institution. Across the board, I think Middle East and even the international arbitral institutions, we see this mandated also in the arbitration rules and provisions. We see this in the new DIAC, SCCA, Arbitrate AD. All of these rules have been revised in the Middle East from 2022 till date, till 2024, and all of them have a very clear provision for the tribunals to then have or use their own discretion to opt for either virtual or a hybrid hearing arrangement, again using their discretion, because that's obviously, it depends on the type of dispute, how many fact witnesses are there, how many expert witnesses are there, the value of the claim as well. And so far, in my experience, tribunals are doing a really good job to making sure that the more lower to mid-value claims and disputes are being heard virtually or in a hybrid setting. Hybrid meaning, let's say, a couple of people in different conference rooms being connected in sort of a main platform. And that really works well, depending again on who the other sides are and who the experts and witnesses are. And we also see then parties and tribunals also curbing their travels for procedural hearings, for example. That's almost non-existent. I mean, back in the day, we all would fly for procedural hearings, which would be an hour, and then just take the day off and have a mini holiday or a break. But in the Middle East, we don't see this as often. I do see this in a fair bit, some still happening in my Asian cases in Hong Kong, especially where we have tribunals sitting in different countries across the world. So they still feel having that sort of FaceTime at the get-go might be important. But in the region here, it is actually pretty advanced, so we don't see this. And we see steps being taken, even with the older arbitrators, to really make a conscious effort to opt for virtual bundling and to really put it in the procedural orders from the get-go in the terms of reference that this is going to be a consideration taken by the party. So I think we've really done a great step forward in the Middle East for these considerations.
And I guess as well as being green, they reduce costs for the parties as well, if you're not paying for everyone to travel across the world and take time out.
Yeah, true. I think that's debatable though, because there's added cost of making sure the electronic bundle is to that standard.
Yeah.
But I think you have to balance it all. You have to take it all into consideration and see what gives you a better quality of a hearing in any event.
Fatima and Sam, do you have any strong opinions on virtual hearings? I know it's one of those love-hate.
Yeah, I mean, I think, I think there's in my experience, and when I sit as well, there's a presumption I always put that it should be virtual unless there's cross-examination. I think, for me, as an advocate as well as an arbitrator, I really benefit from seeing a person in cross-examination, and that's just one of those things that you will never get used to, I think, because there are certain nuances in someone's body language when it comes to credibility that you will see in person, but you're just not going to see virtually.
I think it was at the beginning of COVID, it was either go all the way into virtual hearings or, all the way into in-person hearings. And I think as everything in life, all things in moderation, there's a time and a place for a virtual hearing, and there's a time and place for an in-person hearing, especially here in the region in civil jurisdiction-based cases, even arbitration cases, where the main focus is on a memorandum exchange. There is absolutely no need for but I agree with Sam. If there is a cross examination, there is nothing like experiencing that in person. Yeah.
Fantastic. Well, we've hit 9:30, which is the end of today's session. Thank you so much, Sam, Fatima, and Khushboo, for joining us. Hope we see some of you in Riyadh. Of course, the four of us will be there, along with so many other fantastic speakers from the region and from around the world. As always, we'll be back again next month. We'll announce details of the next session very, very soon. So nothing left but me to say thank you to everyone for joining us, and see you next time.
Thanks very much.
Thank you so much. Bye.